cheapest legal problem to solve is the one that you've identified before it even happens in the first place. My name is Dustin Lee. I'm the founder of Ascend Legal Solutions. We're a business law firm in the state of Texas. This video is for educational and informational purposes only. Nothing in this video is securities advice, legal advice, tax advice, financial advice, or any other kind of advice. Also, nothing in this video creates an attorney-client relationship. In this video, you're going to get 6 practical moments when a scaling Texas business owner may want to consult a business lawyer. We're not trying to turn every single business decision into a legal work project, but you want to make sure that you're protected. Essentially, you're trying to save real money later on down the line by doing good, proactive legal work now. We're going to cover a few things. First, why your LLC formation is not just a paperwork filing with the state, and why there's actually a lot more to it. Second is why bringing in another owner or a partner, either when you form the business or later on down the line, can be one of the most expensive things that you can do. The third thing is why major contracts and commercial leases should not just be treated as routine paperwork. Fourth is why hiring key employees or contractors is a lot more than just paperwork as well, and how it can create issues later on down the road. Fifth, why buying or selling a business is not the time to learn about how the deal documents and the transaction actually works. And sixth, I know you're not going to be able to solve every issue that pops up with your business by being proactive, so the earliest that you can possibly contact someone or be strategic is the cheapest point to do it. Filing your LLC paperwork with the state is actually really easy to do, but doing all the internal work, structure, and documents is actually quite challenging. And building one that actually fits your business is where most owners mess up. A formation of a business feels really simple. So like in Texas, you file your certificate of formation with the Texas Secretary of State, and you feel like you're good to go. But that's not actually true. The filing is only the start of the structure. And then there's a lot of internal documents like your operating agreement and resolutions that really round that out. The operating agreement, or company agreement, sometimes it's called, is where the big pitfall really is, especially in multi-owner or multi-member LLCs. If it doesn't answer the critical things like how decisions are made, how profit and loss is handled, how voting is handled, what happens in a buyout situation, and a whole handful of other things, then you may have a problem later on down the line. That company agreement or operating agreement, that is the governing document that talks about the relationship between the owners, the members, and even the managers. It also maybe even talks about the officers of the entity. If you're doing a DIY formation, or maybe you've used one of these budget formation services, you probably either don't have an operating agreement at all, or maybe you have an extremely basic template operating agreement, and those really just don't serve your business very well because they haven't been customized for your business or your personal needs. This is actually one where calling a lawyer early can save you a lot of money later on. Now, not everybody needs a 100-page operating agreement, but especially in multi-member, multi-owner situations, having that clear authority, having that clear expectations for things like the buyout, voting, profit and loss, as well as what happens whenever one person wants to sell, the other doesn't, or what happens when someone dies, what happens when someone becomes divorced in a community property state. All these things are really key, critical issues that ought to be addressed in the operating agreement, and they ought to be addressed on the front end rather than after they become problems later on down the line. I actually see this all the time. I've had more than one of this issue pop up just this week. People come into my office with either no operating agreement or just a very templated operating agreement in a multi-owner structure, and they've got a dispute between the owners. One owner is either not contributing money or not contributing services in the way that they're supposed to, but it wasn't ever addressed in the operating agreement on the front end, and now they're in trouble. Another time to contact a lawyer about your LLC, the structure or the operating agreement, is whenever you start to grow. Now, growth is good, but when a side hustle becomes a full business, or when you add a partner, or when you take on financing to really expand a lot, these things create additional pressure, and they create additional complexity in the legal issues that your business has to deal with. In addition to that, sometimes I'll see, actually quite frequently, when they didn't get the help of a lawyer, people that form their own LLCs, they don't know about their ongoing filing requirements. Like, for example, in Texas, every year you have to file your public information report, and depending on how much money you make, you may have to file your franchise tax report and pay franchise taxes. For example, here, a single owner business takes off, really grows a lot, and the single owner really needs some help, so brings on a new co-owner to help out with the business, but never updates the legal documents, never updates who can sign bank accounts, who has the authority to make decisions for the business, what needs to be a unanimous vote versus what one person can do on their own. None of the documents get updated, and then later on there's a problem, and it ends up in a disaster. The question is not really whether you formed your LLC in the first place, it's whether you set it up correctly initially, and then also whether it's still set up correctly for the way that your business is actually functioning and operating today. A bad partner deal doesn't usually look bad on day one. Everybody's happy. But it starts to look bad when money, control, authority, or workload is on the line and disputes pop up. So bringing in a co-owner on a handshake deal isn't all that it's cracked up to be. Even if you don't have an operating agreement, which you should, it changes control, it changes economics, it changes voting, it changes profit and loss, and it just changes expectations for the entity as a whole. When you don't have a formal operating agreement between the owners, The issue is not whether someone is trying to potentially be fraudulent or lie, which that happens sometimes. But really the issue is that because it's not in writing, the two parties, they remember the deal differently, they remember their obligations differently, and then disputes are really easy to pop up down the road. This is especially true when the business faces important financial decisions or just big business decisions in general, where there potentially could be a deadlock. Common issues that you want to address just generally, and this is not a complete list: ownership percentages, capital contributions, who's allowed to make decisions, what decisions need to be made with a unanimous consent versus what can one partner do without the other's consent, who can bind the company, what happens if someone stops working, what happens if someone wants out, and also what happens if one person wants to sell their interest in the company or the entire company and the other person does not. So this is where your operating agreement or your company agreement comes in. A well-drafted company agreement or operating agreement addresses all these things and more so that you don't end up in court. I know it's a really hard conversation to have when you're going into a partnership, when everybody feels excited and everybody trusts one another. Sometimes you don't want to put stuff like this down in writing. Maybe it feels like you don't trust the other person, but I'd say the highest form of trust is being able to put all this stuff down in a document. Really, one of the most critical things is the buy-sell agreement. So what happens when one person wants out? What happens when they want to sell? Or what happens if somebody offers to buy the whole company? Only one of you wants to sell, the other does not. But also there's some really important buy-sell provisions that can trigger, like upon the death or disability of one of the partners, or divorce of one of the partners if you're in a community property state. In addition to that, what happens if one of the partners files bankruptcy or has a receiver appointed or someone seeks a charging order? All these things are things that ought to be considered in your operating agreement. Here's a general example, which actually I see all the time, probably at least once a week we hear about something like this, where there's a 50-50 split. One partner ends up doing 70-hour work weeks and financial contributions, and the other partner puts in no time, the other partner puts in no money, but they still get a share of the profits of the business. Obviously, that leads to a lot of resentment, disputes, and problems that usually end up in court. Word to the wise: when things are friendly, when things are great, have the conversations early and write it down. You can kind of think of it this way: the best way to plan for your business breakup is when you first got together. The most expensive contract that you might ever sign might be something that you thought was totally standard. Business owners should sign contracts constantly. I mean, think of it this way. You're constantly signing contracts with your customers, with your vendors, maybe with lenders or commercial leases. You're also looking at non-disclosure agreements or confidentiality agreements. You're looking at agreements with your business partners. You're looking at all kinds of contracts all the time. And, honestly, most business owners, they just treat these as a formality. They don't read them, they just sign them, and then problems pop up later on. I can't tell you how many times I've heard this. The counterparty on the other side says, hey, just sign this. It's just our standard contract. Well, what standard means for them is that they've written the contract and it's probably very good for them and very bad for you. Depending on the kind of contract you're signing, there are tons of different clauses that could potentially matter: payment timing, scope of work, change orders, termination rights, limitation of liability, indemnification, arbitration, dispute resolution, attorney's fees. There's an infinite number of things. You can't be guaranteed that if you're not reading this contract or having an attorney assist with it, that you're going to get a good deal. Commercial leases typically are one of those contracts that carry the biggest and longest term obligation that your business may ever have. Outside of payroll to your employees or payments to your contractors, your rent on your commercial lease is probably the most expensive thing that you're going to pay. Maybe advertising is up there as well, but the commercial lease is really quite expensive for most businesses. And so rent is really only one part of the deal in these commercial leases. There's common area maintenance, there's other financial responsibilities that you could be potentially put on the hook for. Taxes, repair obligations are a big one to check. What the tenant versus the landlord is required to repair. Build out, renewal options, you name it. And always, don't forget, look out for the personal guarantees. Now, in Texas breach of contract disputes, Texas Civil Practice and Remedy Code, Chapter 38 talks about recovery of attorney's fees for breach of contract. Even aside from that, a lot of times the attorney's fees clause will be included in the actual contract that you're signing. You really need to be aware of that because the contract, like the commercial lease, can actually put one party on the hook versus the other party. In addition to that, it can create a lot more variability in how the attorney's fees are actually treated, like whether or not expert witnesses' fees are included in there, or what it actually means to prevail in a lawsuit. Because believe it or not, prevailing in a lawsuit and being entitled to attorney's fees is an issue that potentially could get litigated later on. So think about it this way, just a general example. A business signs a vendor contract with a key vendor, a vendor that their entire business relies on. And then they don't even read it, they just sign it. Turns out the contract has a vague scope of work, it doesn't have default terms, and a bunch of other things are missing that would be good for the business to have in case the vendor ever messes up. And then sure enough, 6 months down the line, vendor messes up, vendor starts underperforming, and now your business is in trouble. Early contract review is not about killing the deal, and most often in the times, it doesn't kill the deal. It's really about understanding your risks and your obligations before you sign, and potentially negotiating those things to get a better deal that you can actually live with with now that you know what your risks and obligations are. If someone is delivering work, handling customers, or touching confidential information, the legal issues that you have with your business are already in the room. Now, hiring a new employee or a contractor is more than just some standard paperwork. It creates questions about worker classification, confidentiality of the information of the business, intellectual property if the employee is creating something, customer relations, data access, non-solicitation, non-compete, you name it. Now, folks, a worker classification is really critical here. We're talking about employee versus independent contractor. And there's a number of factors that courts are going to look at. And we go into more detail on that in a different video. But essentially, we're looking at the control factors, behavioral control, financial control, the relationship between the parties, and how much control and authority is the employer exerting over the employee or the contractor. Now, federal law, Texas Workforce Commission, you name it, it's all really clear. There is a pretty hard rule that it doesn't matter what you're calling this person, employee or contractor, they're going to look at the actual relationship between you and the worker. Intellectual property is another trap. When the employee or the contractor creates things, especially like inventions, then you really have to be sure that the company is the one that's going to end up owning that. And there is a very, very critical process that you have to go through to do that. Confidentiality agreements don't have to be extremely complicated, but it's definitely more than just a little one paragraph thing. You have to have a confidentiality agreement or non-disclosure agreement that actually covers the information that the employee or the contractor is touching and that protects that data both now and in the future. So key employees, they create practical risk. Salespeople, they have good relationship with your customers. Operators have a good relationship with your employees and also potentially your customers. Developers know the code. Employees or contractors may be building assets that the company either uses or sells. So for example, a company, they pay a contractor to build software, they assume that they own it, and they later on discover that the contractor's contract never actually says that the company owns it, and the contractor keeps the rights to the software, and then they can go out and sell it to the company's competitors. Things like that are big red flags, and obviously, if you have a lawyer thoroughly reviewing your contracts, that's something that's going to be a red flag that's going to pop up. When people create value for your business, your paperwork needs to show who owns that value and who can use it later. Buying a business is not just about buying some revenue, it's about potentially buying some problems later on down the road that you didn't know about. Business purchase and sale is one of the most common areas where legal issues pop up, primarily in the purchase department, because you now inherited all of the issues that the business already had whenever you took possession. Now, obviously, that's going to depend on whether you structured this as an asset purchase or an equity purchase. So this is going to be for an equity purchase. Early legal assistance in this process really helps here in structuring the deal, because the deal structure in a business purchase and sale is really, really important. Is it going to be an asset sale? Is it going to be an equity sale? What kind of due diligence are we going to be allowed to do? What's the purchase price? What are the closing conditions? All that good stuff. A letter of intent is usually something that you start out with in a business purchase and sale situation. And even that can be a red flag in your process that you want to have a lawyer look at. Don't just assume that your letter of intent is non-binding. I've actually seen letters of intent that intend to be a binding contract. And at a minimum, that letter of intent might bind you to things like confidentiality, exclusivity, etc. Now, due diligence when you are buying a business doesn't just include checking the books. So we're talking about contracts, key employees, contractor relationships, intellectual property ownership, existing litigation, threatened litigation, regulatory issues, you name it. The buyer's job is really to try to figure out what obligations and what problems could potentially be coming along with this deal. And then obviously on the flip side, the seller's trying to get a clean exit, a clean break with no future obligations. A big example that I've seen here in my practice is that the buyer of a business did not get lawyer's assistance in figuring out the structure of the transaction. The structure of the transaction was structured as an asset sale. And basically, the physical assets and some tangible assets came over, but the contracts did not. And so the purchaser was expecting to get the major contract for the business, and they didn't get it. And if they'd had a lawyer to look at this in the first place, they would have understood that the deal structure did not include those contracts. It's very tempting just to not look at any of the paperwork, sign off on all of it, don't do any due diligence, and just get the business because you're really, really excited to buy the business, or the seller, you're really, really excited to exit the business and make some money. However, I'd say the deal that you're excited about still needs to be reviewed. You still have to look at the documents and make sure that they work for you. Contacting a lawyer after the first angry email someone sends is a lot cheaper than hiring a lawyer after you've been served with a lawsuit. Now, business disputes, they usually start before anybody files a lawsuit. They start with missed payments, poor performance, vague contracts, broken promises, delays, partner tension. By the time it gets to a demand letter, it gets more expensive. And by the time it gets to a lawsuit, it's gotten tremendously more expensive. Early legal strategy for a business owner can potentially save you a lot of money. And also, it helps you know about your position moving forward, either into negotiations or into the litigation if need be. The main thing here is understanding your contract rights. So contract suit, obviously, but also things like preserving documents, communicating carefully without exposing yourself to additional risk or liability, avoiding omissions, and also strategizing about when is it time to escalate this. So a lot of people don't know about business disputes. It's not necessarily whether you're right or you're wrong. It's about cost. It's about leverage, collectability, business distraction. How much are you going to be up at night worrying about this? Confidentiality versus reputation. If it's a public filing, how is it going to affect your insurance? The timing of the whole thing. Does it work for you? And is this really worth pursuing? So next step, obviously, a lot of times there's a demand letter involved. Maybe you've received one. Maybe you sent one. Now, demand letters, folks, they're tools. They are not magic. Sometimes you send a demand letter and you will get an immediate payment in full. Sometimes you won't. Sometimes they'll ignore it, or sometimes they will respond with why they think that they shouldn't have to pay. So short story here is they're a step in the process. They sometimes can help, but even if they don't help actually get the issue resolved, they help escalate. They help make a record. They meet your legal requirements for sending a demand before filing suit. So essentially the business decision here is, does the demand improve your position with respect to any of those? Let's say a contractor dispute starts with a payment issue. Owner fires off a heated email, threatens the things that the contract doesn't support, but then keeps working without actually documenting the problem or working towards a solution. Now the facts are messier than they need to be, and there's some potential, waiver or other types of issues going on. Good dispute strategy, it starts before you're so angry that you can't make a good decision. Today we covered a few things. We talked about how reaching out to a business lawyer in a number of situations can potentially save you more money if you do it early on versus if you do it after the problems have already arisen. We talked about thinking about contacting a business lawyer before you restructure your business, your LLC, and if you don't have an operating agreement, or if your operating agreement doesn't match the actual situation with the business. Think about it before you bring in a partner, an investor, a co-owner, anything like that. Think about it before you sign a major contract, a critical contract that may affect your business, or like a big commercial lease. Think about it before you hire key employees, contractors, anyone creating value for the business or touching the business's confidential information. Think about it before you buy, sell, merge, or restructure a business. And think about it right when a dispute starts, not when it comes into a full-blown fight that's already in litigation. If you remember nothing else, remember this. Legal assistance is the cheapest and most effective whenever it's early before problems arise, and it's the most expensive by orders of magnitude more after the problem is already here. Get yourself some assistance to make better business decisions before the damage is already done. If you found this video useful, just subscribe for more practical business law education for Texas business owners.